159, People versus Hardy. Counsel, you'd like any rebuttal time?
I would, Your Honor. 2 minutes, please.
2 minutes. Go ahead, counsel.
Good afternoon, Your Honors. Eunice Lee from the Office of the Appellate Defender for Pettis Hardy. Pettis Hardy was entitled to a circumstantial evidence instruction in this case.
What? There was no direct evidence?
There was no direct evidence of larceny. In this case, we don't have...
The video is not direct evidence?
Well, with regard to the video, first I would note that below, the people only argued that the statement was the direct evidence in this case, and so there's no basis for assuming, in fact, that the trial court ever held that the video was direct evidence, so it's not clear.
Didn't they start by saying that it was the statement, and then the court granted it, and there was really no opportunity to then go through and say everything that they thought was direct evidence?
Actually, Your Honor, the way that this occurred, when the defense counsel made the request for the charge, he said the evidence in this case is subject to multiple inferences, both the video and the testimony. He raised that in making the request. In response to that specific request, all the people said was the statement is direct evidence, and the court ruled. So it's in fact more likely that the basis for the court's decision was a finding that it was the statement that made it direct evidence. But even accepting that the video as direct evidence is a reviewable claim, it does not, in fact, constitute direct evidence.
What would you like to have had the judge say that was not said in terms of circumstantial evidence?
Well, the critical thing that the judge should have said was that for the jury to convict in this case, they had to find that the evidence excluded every reasonable hypothesis of innocence. That critical concept that you can't convict unless you decide that every inference of innocence can be excluded here, that's absolutely missing from the instruction that the court did give. The judge's instruction talked about weighing circumstantial evidence with regard to individual facts, but it never talks about...
What could be more direct evidence than the video? What could it be if it's not direct evidence?
Well, the problem with the video, Your Honor, is what the video shows, it doesn't indicate the video is not direct evidence of a larceny here. The video shows
it's an evidence of a taking. Now, how you interpret that, of course, is up to the jury, but it's about as direct as you can get of a taking.
Well,
now, you could have put different interpretations on it. Slow down. You could have said that was his job to move things from one place to another. Those are reasonable interpretations. But it still makes the evidence direct. I'm having a hard time seeing that.
Well, it's direct evidence of his actual physical handling of the purse, but a taking in the legal sense, meaning that he's exercising dominion and control over the item in a way that's inconsistent with the rights of the owner. I would argue that...
Sometimes evidence can be direct without being dispositive. If they had a video of him taking the purse and walking down the street and going to the apartment, that would be dispositive, right? But here, it's direct, but not dispositive. I agree with you that it's not dispositive.
It's beyond, though, not being dispositive. It, in fact, is not direct, because here where there's an alternative inference for his handling of the purse, it doesn't establish a taking in the sense of he's exercising control of this purse in a way that's inconsistent with the rights of the owner.
How do you get there, Ms. Lee, when the video shows, my recollection of the description of it shows that as soon as the woman who owns the purse sort of turns her back, that's when the defendant is seen on the video picking the purse up. He's kind of angled his body so that she doesn't see him picking up the purse, and then he puts it down, and as soon as she leaves, he's going through the purse. And then picks it up and takes it with him somewhere.
It's certainly his handling of the complainant's purse and what's depicted on the video is certainly incriminating and certainly is subject to an inference of his guilt. But the question is, given that inferences have to be made to get to that stage of concluding this to be a larceny, was he still entitled to this instruction? It certainly is. There are certainly suspicious and damaging inferences to be made from that, but given his role as an employee and that he's working at this night, and in fact that he was at various points authorized to move the belongings of individuals in the club, the mere act of his handling and what's seen on the video, that in and of itself does not establish a taking. It's not direct evidence of a taking.
Was the authorization to move property within the club, was that during the actual events going on in the club? I thought by the time that he picked up her purse, those events were over, things were being wrapped up. So you think it was still his he was still authorized to pick up this particular purse?
Well, essentially throughout the night, what he was instructed to do was to keep people and their belongings away from the bar area for as long as people were going to be in the club, because they were concerned about theft. And so it's his duties in terms of that continued throughout the night. But I think the issue is not whether or not he had specific authorization to move this complainant's purse at that particular time. It's a question of, given that he did have this authorization, that he is working in the club as an employee, are there alternative inferences that can be made from that act? Can we look at that act and say, this is direct evidence of a legal taking? And in this context,
you can
that
never
can't-
have direct evidence that's subject to different explanations or inferences as to what it means?
Well, what's required for the charge is direct evidence going specifically to the criminal act. It's not merely direct
It's
evidence
not
of...
direct evidence that he opens up the bag and he looks through it and he's later shown taking it? I mean, could there be anything more direct as to the taking? And as Judge Fahey indicated before, not necessarily dispositive. Maybe there's a rational explanation, but
Well,
I don't know what could be more direct relating to the taking itself.
Well, again, it's a question of, it is incriminating. Is this direct where he is not seen, and the video does not depict him leaving it? So has he handled this bag, has he engaged with this bag in a way that is inconsistent with the owner's continued rights when he's seen picking it up, he's seen putting it back down, and he's working in this club that night? And so in this situation, yes, it is, in fact, it's evidence of movement of some kind. Is it evidence of a legal taking? Is it, actually, I guess the question, is it direct evidence?
He's seen handling the bag. He's been talking to her. He knows it's her bag. Looks like a taking.
Well, I think, again, I think what Your Honors are focusing on to some extent is this idea that is this incriminating, and does this make him, is there an inference of guilt that can be made from that? And we're not disputing that at all. The question is this in the nature of direct evidence where there is, in fact, an alternative inference for his
To be clear,
handling
then
of the bag?
what would have been direct evidence? What more would he have done on the video?
Well,
Actually physically walk out
certainly,
with it?
certainly if he had physically walked out, that would be one scenario that would support that.
Well,
There could-
but in that case, couldn't there also be other inferences that he was going to return it to her, or any
Correct.
number
I
of
mean, and
things?
that's, well,
So how's that different?
Well,
Why is there a dividing line between inside the building and outside the building?
well, it's not really inside the building, outside the building. It's looking at basically the entire circumstances of what's going on this night. If a stranger,
You just said it's a stronger inference if he walks out the door.
it's
Well, in this case, he walked by her, so if he's really going to give her the bag, he would have given her the bag.
well, I mean, again,
So
it's
in the facts of this case, if he's walking out, if the video is showing him walking out, and she says, I saw him,
in the facts of this case, there are certainly inferences that can support that, but given what else is going on, it's a question of, is this circumstantial evidence? It might be compelling circumstantial
So
evidence.
go back to answering the question. What is it that would be direct evidence that isn't subject to different inferences? What would have been that we could say is direct evidence? He took it in his hand, and he had it, and you showed him leaving and getting into his car. That's direct evidence that wouldn't be subject to different inferences?
Perhaps that, something along those lines, or perhaps if he's shown taking the bag and putting it into his backpack and zipping his personal backpack up, something along those lines.
But maybe he's protecting it for her. He's taking it to put it somewhere else. There's always going to be, I guess what we're trying to get at is, there's always going to be different explanations for what's shown on the video, but how do you distinguish what's direct and not direct? Because anything you could say is subject to different inferences.
Well, when there's something that's unequivocally, when it establishes something that is unequivocally an element of the offense or goes directly to the offense, that is something that you can say that is direct evidence of it, as opposed to something that requires an interpretation or an inference to come to the conclusion of,
Okay.
yes, this is an element.
Let's hear from your adversary, then you have rebuttal.
Good afternoon, Your Honors. May it please the Court. Obviously, Your
Counsel,
Honor.
deal with this issue about the video. Is it direct evidence of taking, or is it, as your adversary says, Yeah, he had it at one time, he didn't have it at other times. There are lots of different reasons, and it's not direct evidence. How do we determine what's direct and what's not?
Well, direct evidence, Your Honor, here, it has to be a taking, and it has to be moved slightly. That's what People v. Olivo says. And here...
If he took the purse,
Right.
and he just moved it from on the bar to over to a chair, is that, because he wanted to move it off the bar, is that direct evidence of taking?
They have an explanation, but as you said, it's not dispositive.
But that would still be direct.
Absolutely.
If he just picked it up and his job was, and we know his job was to keep those kinds of items away from the bar. If he took it, it was on the bar, moved it away from the bar, that's direct evidence?
Yes, because...
Of the taking?
Of asportation, of the asportation element from Olivo, at least in our opinion. But you don't even have to get there for this particular case, because in this case, it's clearly inconsistent with the owner's continuous right of possession. Not only does the owner of the bag sitting there, he blocks it, he takes it off the top of the couch and blocks it from her view, then waits for her to leave, then rifles through for a minute. If that is not something that's inconsistent...
Yeah, but that wasn't my question. My question was, what if he just took it off the bar, his job was to keep those kinds of items off the bar, and put it down somewhere else, like near the owner?
I would look at the Lecitra case because...
That's still direct evidence
Absolutely.
of taking?
Of taking, absolutely.
If he took it off the bar and she's sitting over where Judge Stein is, and he takes it and he puts it right near her, that's direct evidence
If you have a
of
video
taking?
of that, yes, because it's a desired fact that you're proving through standalone evidence. It's not, you don't have to make any inference. He took it and he gave it to Judge Stein.
You're saying that's one element, and then, but it doesn't go to the element, for example, of intent.
Guilt, exactly. It doesn't go to guilt. Right? And nobody's saying that it has to go, like, a direct piece of evidence has to go to guilt by itself.
Or intent.
Or intent, right? Because even your own cases
So
here...
you're saying any video that has him touching that bag is direct evidence?
Direct evidence. But it doesn't mean he's guilty. That's the difference.
Would it be the same, counsel, if someone had witnessed him picking up the bag and moving it from the bar and rifling through it and testified to that? Would that be direct evidence?
If someone saw it and testified, absolutely, it's the same thing.
That's what I'm asking. So
Yes.
the video, you're suggesting that the video is like a witness testifying almost.
Absolutely. Because, and also I want to get back to, before, one of the points you were making about his duties. The record here says, and I know this is slightly astray from your question, Judge Lippman, but the record does say here that the witness had no responsibility to move any bags by a couch. At best, the manager of the club said that he had said he should look at the bar and make sure that people weren't going behind the bar. But he had never said he could move it off the couch. And his own witness said the only thing that he told him was to move it off the bar. The couch is up the stairs from the bar and the distance from the back of the bar. So I just don't understand their position in the end, how this is not
Well, those are all the elements that go to the proving of a petty larceny or some kind of a larceny, but it doesn't deal with the direct evidence question. Isn't the point more succinctly that direct evidence is proof of a fact that you can draw in the absence of an inference? Circumstantial evidence requires an inference. The direct evidence can then be used to infer meeting the elements or the 5 or 6 elements, but that's not what we have here. So your argument is at its core, the film is just like somebody testifying in court that they saw him do.
yes.
Yeah. Okay.
Let's say we disagree with you. What about the statement?
See, the statement, though, again, and that's why I agree with Justice Fahey, because in the end, it's an inference. But this court in Rumble, I want to read this court's language in Rumble, because I think it's very important for the statement. If interpreted by the fact finder as a relative admission of guilt, distinguishes this case from those based exclusively on circumstantial evidence. And the reason that is, Your Honor, is in that case, he said, I'm not responsible for what I did. Now, do we know what I did means? You have to take a little bit of an interpretation. It doesn't mean you have to take a huge leap, but you have to take an interpretation, as this court said.
But here, he didn't say he did anything. He didn't say he removed it. He didn't say he had it, he possessed it. He just said he knew where it was.
Well, Your Honor, in the context of this statement, we believe he did. Because remember, first, he's called up and asked about the purse, and he goes, I don't know anything about that. Then he says, then they said, we got you on video. And he says, I don't have it, but I can't get it. And he goes, I don't have it, but I can get it. So he didn't deny it again now.
But unlike the video, how do you prove any element from that statement without drawing inferences from all the circumstances?
Because, as Rumble says, it could be interpreted by the fact finder as an admission of guilt. There are going to be many cases of direct evidence.
The problem is it's, as I agree with Judge Stein, I don't have it, but I can get it, can also mean somebody else has it. It requires inferences. Now, we're proving facts here, not guilt, because all proof of guilt is an inference. But a proof of a fact that requires an inference has to be circumstantial. And so here, that statement, unless he says, I did it, I'll see if I can get it.
No, but in Rumble,
Doesn't get you there.
In Rumble, Your Honor, he said, I did. What did he do? Did he start the fire?
A little different statement, I have to say. You know?
Well, I understand that it's not exactly on point, but the language in Rumble says...
It's a language that suggests liability, criminal liability, culpability.
Well, the
Whereas,
I'm sorry.
I don't have it.
Right.
I didn't do it.
He knows who the person is.
I can get it.
He knows
I can get it.
He knows who the person is. He says he knows who the person is. He wants to call her. He says, I can get it. Now, we're talking about a bag that was stolen.
So why did it take the jury so long to reach a verdict? The way you're talking, they should have been out about 20 minutes.
I wasn't in the room. I wasn't there, and I can't speak to what 12 people want to do. You ask 12 people to go to a movie, it's going to be a tough decision.
And it may be that they were having difficulty interpreting this evidence that they had. And I think counsel's argument is that's why you give them a circumstantial evidence charge, and you should give them a full one.
Well, just because evidence is difficult doesn't mean you get a circumstantial evidence charge, Your Honor. You get a circumstantial evidence charge if the evidence is wholly or entirely circumstantial.
Right. If it's subject to different interpretations, I mean, the purse business, the video business, I mean, obviously, if it was absolutely as direct as you seem to imply, they shouldn't have had any trouble at all.
But I can't put myself in that room. I can only look at the evidence from what is in the record. Now, you bring 12 members of the community in, you have 12 people, and
No,
I
but
can't...
that gets us to the whole Allen charge business and how long this jury was out and whether the Allen charge was appropriate. I take it you were because you...
Well, they don't contest that the Allen charge is inappropriate.
Right, and you moved for it.
We
right?
moved for
And
it.
they did not object.
Well, no, they objected. They wanted a mistrial, but on appeal, they don't have any problems with Judge Allen's Allen charge.
The text itself.
The text itself, correct. Their only issue is whether it should have been
given to begin with.
Exactly. And for the reasons we stated in our brief, we believe that a mistrial here was totally unwarranted, that they should have went on. They never said the word deadlock. They never said, that there's any dissension in the jury room. There was 5 witnesses. There was videos to different interpretations. They had deliberated for the first note at under 7 hours, the second note at 11 and a half hours. And for all the factors that this court has set forth, we don't believe that...
When do they come back after the second Allen charge? How long does it take them?
Second Allen charge, I believe they got it at 3 o'clock, and I believe it's about 10... No, it was 1 o'clock the day before, and I think they came back at 4:34 that day. So about 3.5 hours. And they deliberated, and they asked for more notes.
4:34 being 4 minutes past the time that...
Yes, which defense counsel at the time didn't say anything about. Didn't object to that. And to the extent that they're making a point about that now, I really fail to understand that point, because the jury, if they wanted to leave, they wanted to get out of there, and they thought that 4:30 was going to make them come back the next day, they would have wrote the note at 4:15.
Okay, Counsel.
Thank you.
Thanks. Counselor, rebuttal?
Yes, thank you. Your Honors, with regard to what the problem was that the jury had in this case, The reason I would suggest that it took so long for them to reach a decision here is that this case was all about inferences. They didn't have to make decisions about the credibility of the witnesses. Most of the testimony as to the surrounding circumstances was undisputed. What was going on here is, what do we make of this? How do we interpret it? And in fact, the evidence in this case, including the video and including the statement, was circumstantial. That's part of what was going on here. With regard to the idea that the statement is somehow direct evidence of guilt, it's very clear that it's not. In the cases cited in the brief, where individuals admit to being able to obtain stolen property, that is not direct evidence of larceny, and there's no cases cited directly on point to refute that. Also, with regard to the questions raised as to the video, is what's in the video enough? The video does present evidence of facts that are relevant to what's going on, and certainly facts that are incriminating, but it has to be facts that go to the offense for it to be considered direct evidence.
Counsel,
For instance,
you would then say that this is not like a witness testifying to what that witness saw. If the video had been a person saying, I saw the defendant do this and do this and do the other thing, you would say, no, that's not direct evidence?
it's still, if a witness testified to what's depicted in the video and simply said, I saw him move here and do this, that, under that circumstance as well, that would still be circumstantial evidence, because it doesn't go to, it's not evidence of a taking that goes to the specifics of the offense. For instance, with regard to the idea that it does show facts that happen, if you look at what this Court said in the Sanchez case, for instance, the defendant in that case was accused of strangulation. He gave a statement admitting being in the same room with the victim at the time that this occurred. Now, certainly, you have to be present to that's a factor you have to be present to strangle someone, but the Court concluded that the evidence in the case was still circumstantial, because the admission of his presence didn't go to the elements or to the acts of the actual strangulation. That's part of, it's similar to what.
Here, we don't have a video of the defendant in the room, just in the room. If that was it, we probably would have,
Right, but what the video shows.
time with this.
Right, but what the video shows is, again, it doesn't show something that establishes on the face of it a taking, in the sense of it's inconsistent, that the only inference to be made is that his handling of this purse is inconsistent.
It's only direct evidence if there is no other inference that could possibly be drawn. Is that?
If on the, essentially on the face of it, yes, that it's, as it goes to the elements of the offense, if that's the inference that can be made, then it's direct. Here, we don't have that.
Okay, guys. Thank you both. Appreciate it.